Amino is still on record with us, but we're holding his brief. I'll leave the respondents to go on these themselves.
Morning, my lord. I am in group appearing together with Mr. Ongaro for the interest of
last night, and I can assure my lord that if you allow us just a few days to familiarize ourselves with the orders made, at the next hearing, we shall ensure that all that is to be done. I've assured the Senator and the team that, my lord, all we need is a few days to familiarize with this matter, and then we shall have very, very useful engagement, devoid of any less side shows, my lord. And the request is just a few days, maybe to Tuesday or Wednesday, whichever day it is suitable to my lord and to my learned friends.
Yes, Mr.
My lord, I'm aware that for purposes of record, my two senior colleagues would have action if we take another date.
Yes, Mr. Gacha.
Yes.
I'm reading here. Because the matters before this court are under the bridge. The waters under the bridge.
Sorry?
The matters you are seeking to pursue may be waters under the bridge.
Yes.
Yeah, so I would ask you to listen to my ruling. And then after that, you can determine what course of action you should take. Okay, this is my ruling. The applicant Miguna was arrested on 2nd February 2018. Was arrested on 2nd February 2018 by the police. On the same day, he filed an application before this court seeking his release on anticipatory bail, pending his production before court. The court, that is Justice Wakiaga, upon certifying the application urgent, ordered the applicant to be released on anticipatory bail upon paying a cash bail of 50,000 shillings. If the applicant was released as ordered by the court, he was required to appear in person before the court on 5th February 2018. This court made the following further orders, and I quote, the court made the following further orders, and I quote, in the alternative, should the respondents intend to charge the applicant with any known offense, then the same is to appear before the said court as soon as required, if it is to be before his appearance before this court, end of quote. The court further ordered the second respondents to be personally served with the order. From the record, it was apparent that the respondents were served as ordered by the court. The applicant was not released as ordered by the court. When the parties appeared before this court on 5th February 2018, it became apparent that in defiance with the above order, the applicant had not been produced before the court. This court reiterated the orders that were issued by the court on 2nd February 2018 and directed that the applicant be produced before the court by the second and third respondents. This court required personal attendance of the second and third respondents in court to give an explanation why the applicant had not been presented before court so that he could be dealt with in accordance with the law. The court listed the application for hearing on 6th February 2018. This court stated the following in its ruling, and I quote, it is apparent that the Inspector General of Police and the Director of Criminal Investigations are in contempt of the orders of this court. Article 49(1) of the Constitution sets out certain non-derogable rights in relation to an arrested person. That right includes the right for an arrested person to be produced in court within 24 hours of his arrest and to be tried, or in the alternative, he be released. End of quote. And I further quoted, in the circumstances therefore to remedy the situation, this court orders Inspector General of Police, Mr. Joseph Boinnet, and the Director of Criminal Investigation, Mr. George Kinoti, to appear before this court personally to show cause why they should not be punished for being in contempt of orders of this court. They are further ordered to personally produce the applicant Miguna before this court so that it can be dealt with in accordance with the law. This appearance shall be made on 6th February 2018 at 9 a.m. The Director of Public Prosecution to serve the order of this court. It is so ordered. End of quote. When the parties appeared before this court on 6th February 2018, the court was informed by Mr. Mutuku that the second and third respondents had been duly served as ordered by the court. They had sent 2 representatives to represent them in court. More importantly, the court was informed that the applicant was scheduled to appear before the Chief Magistrate's Court at Kajiado. A copy of the draft charge sheet was presented to court. The applicant's counsel and the counsel for the Law Society of Kenya were not impressed by the failure of the second and third respondents to produce the applicant before court. This court sought to confirm that indeed the applicant had been presented before court. The court adjourned its session to 12:30 p.m. to confirm that the applicant had been presented before court. At that time, Mr. Mutuku told the court that the applicant was being presented before Honorable Edwin Mulochi, resident magistrate. At the time, the parties were making presentations before that court on whether the applicant should take plea in view of the order that had earlier been issued by this court to the effect that the applicant be presented before it. Meanwhile, the court reserved the delivery of its ruling on the submission that had been made, that had earlier been made before it for 2:30 p.m. on the same day. After hearing the parties, Honorable Edwin Mulochi rendered his ruling on the following terms, and I quote: the police do produce the accused suspect before the High Court at Nairobi before 3 p.m. today. 2. Once the issue pending are conclusively thrashed out by the High Court, the accused can be brought to this court for plea on 14 February 2018. Pursuant to this order, the applicant was required to be produced before this court by 3 p.m. This court rendered its second ruling in this matter at about 3:30 p.m. At that time, the court orderlies informed the court that indeed the applicant had been brought to the holding cells within the court precincts. This court ordered the applicant to be released on the basis of the cash bail of 50,000 that he had paid on 2nd February 2018. Concern was raised by the counsel for the applicant that there was possibility that the second and third respondents may not comply with the orders of this court by producing the applicant before court. This court assured the parties that it would not leave the court premises until it had been confirmed that the applicant had been released. As is now common knowledge, this court waited within the court precinct until 6:50 p.m. when it became apparent that the second and third respondents would not produce the applicant. Mr. Ondimo for the state told the court the following, and I quote him: I got information from the director CID. He is out of town. He was unable to reach them through their mobile phones. He has not been able to tell us where the applicant is. I have not got in touch with the OC flying squad. I have been trying to call him to confirm if the applicant has been brought. He has not responded. We have no information as to the whereabouts of the applicants. End of quote. On the basis of this information, the court wrote the third ruling in the matter. It made the following order, and I quote: it is apparent that the second and third respondents are in contempt of the orders of this court. They have refused or failed to surrender the applicant to this court so that he can be released in terms of the orders issued today. It is clear that unless this court takes appropriate remedial action, the second and third respondents will continue to treat the orders of this court with impunity. End of quote. The court directed the applicants to be produced to this court by 11 a.m. on 7th February 2018. This court also suspended any criminal proceedings against the applicant pending his presentation before court. The third respondent and Mr. Said, the officer in charge of flying squad, were ordered to personally present the applicant before court. On 7th February 2018, Mr. Mutuku, the Deputy Director of Public Prosecution, told the court that the applicant had been deported from the country the previous night pursuant to a declaration issued by Fred Matiang'i, Cabinet Secretary for Interior and Coordination of National Government, pursuant to Section 43 and Section 33, Sections 43 and Sections 33(1) of the Kenya Citizenship and Immigration Act of 2011. The copies of the declaration were presented to court as evidence that the applicant was no longer within the jurisdiction of the court. The declarations were dated 6th February 2018. It was clear from the submission made by Mr. Mutuku that the applicant was deported upon receipt of a letter written to the Ministry of Foreign Affairs by the Canadian High Commission. The letter was received on the same 6th February 2018. In the letter, the High Commission requested the Kenya government to allow its officers access to see the applicant in view of the fact that the applicant was a Canadian citizen. The High Commission was concerned that they were unable to verify or confirm the well-being of the applicant due to the fact that he was being kept incommunicado. The applicant's consent urged the court to take appropriate action to uphold the authority of the court in light of the fact that it was obvious that the second and third respondents had breached the orders of this court requiring them to produce the applicant before the court. In its fourth ruling in the matter, the court directed the second and third respondents and the Director of Immigration, Major General Retired Gordon Kialangwa, to swear affidavits to indicate the circumstances under which the second and third respondents removed the applicant from the custody of the court and handed him over to the Director of Immigration. This court further made the following orders, and I quote: the second respondent, Mr. George Kinoti, and the third respondent, Mr. Joseph Boinnet, must further swear affidavits to show cause why they should not be punished in accordance with the Contempt of Court Act for disobeying the orders of this court. They are required to appear before this court in person on 15th February 2018 at 9 a.m. to show cause, end of quote. The proceedings were adjourned to today when the third and second respondents are required to be present before court. Meanwhile, the court did receive the affidavit sworn by Joseph Kipchirchir Boinnet, the Inspector General of Police, George Kinoti, the Director of Criminal Investigation, and Major General Gordon Kialangwa, the Director of Immigration. In the said affidavit, it was clear to this court that the second and third respondents, though stating that they had no intention or had never had the intention to disobey the orders of this court, that they had indeed deliberately disobeyed the orders of the court by creatively interpreting it to avoid liability for contempt. The second respondent swore as follows, and I quote, that by the time I was made aware of the existence of the third ruling, I had already been informed by DCI that he had given instructions that the applicant be released pursuant to the direction issued by the Honorable Court, directing the release on a 50,000 shillings cash bail, end of quote. The third respondent, George Kinoti, swore the following paragraphs in his affidavit, and I quote him, that by the time I was being made aware of the existence of the third ruling, I had already given instructions that the applicant be released by the officers who had escorted him to Kajiado Chief Magistrate's Court, pursuant to the directions issued by this Honorable Court for his release on 50,000 shillings cash bail. I am aware that the applicant was released at 1800 hours, that is 6 p.m., as per the attached OB. 14, that I was informed by my officers that the applicant was released by OB number 6/2/18 at Inland Container Depot, ICD Police Station, pursuant to the orders issued by this court, end of quote. In his affidavit, Major General Gordon Kialangwa told the court that he brought to the attention of the Cabinet Secretary, Minister of Interior, the fact that the applicant was a Canadian citizen, and at the time he applied to be granted the Kenyan passport. This is what he said, and I quote him, that the Cabinet Secretary in charge of immigration matters on 6 February 2018, issued a declaration under Section 33(1) and Section 43 of the Kenya Citizenship and Immigration Act 2011, referred to a copy of the declaration here with attached and marked as annexure GK6 and GK7. End of quote. No, that is GK6 and GK7. 6, that pursuant to the orders referred to in paragraph 6, I instructed my officers on the 6th February 2018 to ensure that the orders be effected. 8, that on 6 February 2018, the applicant herein was arrested within the precinct of Inland Container Depot, Embakasi, and taken to Jomo Kenyatta International Airport for purpose of deportation, and did board KLM Airlines flight number KA0566 to Toronto, Canada, via Amsterdam. Refer to a copy of the boarding pass herein attached and marked as annexure GK8. And then paragraph 10, that the Department of Immigration was not party to the application. Consequently, we are not aware of the orders of this honorable court, as none had been served on the department. Moreover, if any orders had been brought to the attention of the department, we will definitely have complied. End of quote. It is clear from the affidavits of the second and third respondents and the Director of Immigration that if there was any doubt that the second and third respondents were in contempt of the orders of this court, that doubt was removed by their admission in the actions that they took. That the second and third respondents were aware of the orders of this court that required them to produce the applicant before this court to be dealt with in accordance with the law is confirmed by the above-mentioned in the affidavits. The second and third respondents were aware that pursuant to the orders issued by Honorable Edwin Mlochi at Kajiado Chief Magistrate's Court, the police were required to present the applicant before this court on 6 February 2018 by 3 p.m. The second and third rulings delivered by this court were categorical that the applicant was to be presented before this court. In any event, the Office of the Director of Public Prosecution was represented in court and communicated to the second and third respondents the orders that this court had issued. For the second respondents to claim that they had complied with the orders of this court when instead of producing the applicant before this court before or at 3 p.m., they released him at the Inland Container Depot Police Station at Embakasi at 6 p.m. This court had clearly indicated that the applicant be produced before this court so that he could be dealt with in accordance with the law. If there was any doubt as to what orders in regard to the production of the applicant before this court, the same was reiterated by Honorable Edwin Mlochi, Resident Magistrate at Kajiado Chief Magistrate's Court, who ordered the police to produce the applicant before this court for his release on bail. The second and third respondents acted in contempt of the clear orders of this court, and this court so finds. As public officers, the second and third respondents are mandated under Article 232 of the Constitution to uphold inter alia the following values and principles: high standards of professional ethics, being responsive, prompt, effective, impartial, incapable in the provisions of service to the public. They are also required to be accountable for the administrative actions that they direct in the course of their duties. The second and third respondents are also bound by the national values and principles of governance as espoused in Article 10, Sub-Article 2 of the Constitution, that requires the second and third respondents in the course of their duties to respect human dignity, equity, social justice, inclusiveness, equality, and respect for human rights. Article 3, Sub-Article 1 of the Constitution provides thus: every person has an obligation to uphold, respect, and defend the Constitution. As regards the implementation of rights and fundamental freedoms as provided by the Bill of Rights, Article 21, Sub-Article 1 of the Constitution provides that, and I quote, "It is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bills of Rights," end of quote. Article 243 of the Constitution establishes the National Police Service, to which the second and third respondents are members. Article 244 of the Constitution sets out the objects and functions of the National Police Service. It includes under Sub-Article B the prevention of corruption and promotion of practice of transparency and accountability. Under Sub-Article 3, the police are required to comply with constitutional standards of human rights and fundamental freedoms. Under Sub-Article D, they are required to respect human rights and fundamental freedoms and human dignity. The National Police Service is further guided by the principles of national security, which includes, as provided under Article 238, Sub-Article B, Sub-Article 2, Sub-Article B of the Constitution, the pursuit in court in compliance with the law with the utmost respect to the rule of law, democracy, human rights, and fundamental freedoms. End of quote. When the applicant filed the application to be released on anticipatory bail, he was exercising his constitutional right to secure his liberty as provided under Article 29A of the Constitution that guarantees him the right to freedom and security of person and the right not to be deprived of his freedom arbitrarily or without just cause. The applicant was enforcing the right pursuant to Article 22, Sub-Article 1 of the Constitution that provides that, and I quote, every person has a right to institute court proceedings claiming that a right of fundamental freedom in the Bill of Rights has been denied, violated, or infringed, or threatened. I have underlined the word threatened. End of quote. The basis of the jurisdiction of this court to grant anticipatory bail is provided by the Constitution. As was held by this court in the case of Miguna versus Republic, it is 2014, 1 KLR at page 550 and specifically at page 532, and I quote, where a person is constantly subjected to harassment or is in fear of being unjustifiably arrested, he has a right to recourse to the protection of the Constitution through the High Court, where its enforcement is provided for by the Constitution. It would indeed be a tragedy if the Constitution did not provide a remedy that a citizen whose fundamental rights have been breached, For the respondent to say that a person in such a situation should do nothing because there is no law providing for such a person to seek remedy in court will completely be the antithesis of the spirit of the Constitution, which provides for the protection of fundamental rights and freedoms in the Bill of Rights. We are further of the humble opinion that the right of anticipatory bail has to be called when there are circumstances of serious breaches by an organ of the state of a citizen's fundamental right. End of quote. The above decision was rendered before the promulgation of the Constitution in the year 2010. Unlike then, the Constitution, as cited above, grants a citizen the right to approach the court for appropriate remedy when his right, as provided under the Bill of Rights, is threatened to be infringed. The reasoning in the above case applies to the applicant in this case. Upon his arrest, pursuant to Article 49, Sub-Article 1, F of the Constitution, the applicant had a right to, and I quote, to be brought before a court as soon as reasonably possible, but not later than Roman 1, 24 hours after being arrested, and Roman 2, if 24 hours ends outside ordinary court hours, or on a day that is not ordinary court day, the end of the next court day. End of quote. The applicant was arrested on February 2nd, 2018. This court issued an order releasing him on anticipatory bail on the same day with direction that he presents himself before court on 5th February 2018. The 2nd February 2018 was a Friday. The second and third respondents were required to release the applicant on that 2nd February 2018. They did not. Since they were served, they ought to have released him at least on 3rd February or on 4th February 2018. They did not. When the matter was mentioned before this court on 5th February 2018, the second and third respondent did not present the applicant before court as required under Article 49, Sub-Article 1, F of the Constitution. That is the reason why the court directed the second and third respondents to appear before the court on 6th February and present the applicant to the court so that he could be dealt with in accordance with the law. On 6th February 2018, despite the order issued by this court, twice during the same day, the second and third respondent did not present the applicant before court so that he could be released in accordance with the orders of the court. In the second ruling delivered on 6th February 2018, this court observed the following at page 5, and I quote, It was clear to this court that the second and third respondents acted in clear breach of the orders of this court issued on 2nd February 2018 that required them to release the applicant from their custody pending further orders of the court on 5th February 2018. It is not for the respondent to interpret the legality or the veracity of the order issued by this court. It is not open for the respondents to choose whether or not to comply with the orders issued by this court. As public officers, the second and third respondents are required to lead by example by obeying orders issued by this court. The second and third respondents cannot purport to enforce the law while breaking the law. They acted clearly in contempt of the orders of this court by detaining the applicant in breach of the orders issued by this court. End of quote. This court, therefore, finds the second and third respondents are in contempt of the orders of this court. Section 4, subsection 1, Section 4, subsection 1A of the Contempt of Court Act 2016 provides as follows, and I quote, "Contempt of court includes civil contempt, which means willful disobedience of judgment, decree, direction, order, and other process of a court, or willful breach of an undertaking given to a court." End quote. Section 4, subsection 2 of the Act states as follows: "In any case not related to civil or criminal proceedings as contemplated under Article 1, subsection 1, an act that is willfully committed to interfere, obstruct, or interrupt the due process of the administration of justice in relation to any court, or to lower the authority of a court, or to scandalize a judge, judicial officer in relation to any proceedings before court, or in any other manner, constitutes contempt of court." End of quote. In the legal treatise, Ulrich, Eddy, and Smith on Contempt, that is third edition, published by Thompson, Sweet, and Maxwell at page 144, the authors had this to say in respect of the distinction between civil and criminal contempt of court, and I quote, "Thus, although civil contempt is concerned with breaches of court orders or undertaking in civil litigation, which were originally for the benefit of one or other of the party, the court may wish in such cases to coerce parties into compliance with its orders, or alternatively, even in the context, it may primarily be concerned to punish disobedience where the time of compliance has passed. In such circumstances as this, deterrence clearly has a role to play. It is therefore possible, in many examples of civil contempt, to discern these various policy considerations in operation alongside one another. This was explained by Cross J, for example, in the case of photographic performance versus amusement caterers. A company and its directors were restrained by injunction from playing certain gramophone records in a jukebox. The records in its boxes. The records continued to be played. The judge took the view that the directors of the company were deliberately defying the court. And this is what the court said in that case. Where there has been willful disobedience to an order of the court and a measure of contumacy on the part of defendants, then civil contempt, which is called contempt of procedure, bears a twofold character, implying, as between the parties to proceedings, merely a right to exercise and the ability to submit to a form of civil execution. But as between the party in default and the state, a penal or disciplinary jurisdiction to be exercised by the court in the public interest. Similarly, in the case of Jennison versus Becker, Salmon, Lord Justice made the following important point, and I quote, "The public at large, no less than the individual litigants, have an interest, and a very real interest, in justice being effectively administered." End of quote. So the duality was emphasized by Megary J. in the case of Grantham Wholesale Fruits, Vegetables, and Potato Merchants Limited. And this is what the judge said. In this type of case, a motion for committal is, of course, a means of putting pressure on the contemnor to obey the order. But it is not this alone. It is also a means of imposing any penalty thought proper in respect of the contempt that has already been committed. End of quote. In the context of breaches of interdict law, Justice Lord President Clyde in the case of Johnson versus Grant, drew a similar distinction. Not only has no one the power to purge himself of a deliberate offense by saying he is sorry, but the mere circumstance that he presents a belated expression of contrition has, with regard to public aspects of the matter, almost no importance at all. The appeal is simply to the clemency of the court. There is no palliative. The appeal is simply to the clemency of the court. There is no palliative of the offense at all. And the idea must not be harbored that a person who has willfully committed a breach of interdict can obtain remission of sentence by coming to court and saying, I have realized my transgression and I apologize for it. However sincerely such an apology may be made. End of quote. In the case of Katsuri Limited versus Kapuchand Deepa Shah, it's reported in 2016 volume of Electronic Kenya Law Reports. In defining contempt of court, the court held as follows, and I quote, according to Black's Law Dictionary, contempt is a disregard of, disobedience to, the rules or orders of a legislative or judicial body, or an interruption of the proceedings by disorderly behavior or insolent language in his presence, or so near thereto as to disturb the proceedings or to impair the respect due to such a body. End quote. In Halberry's Laws of England, it is stated, and I quote, it was plain and unqualified obligation of every person against or in respect of whom an order was made by a court of competent jurisdiction to obey it unless and until it was discharged, and disobedience of such an order would, in a general rule, result in the person disobeying it being in contempt and punished by committal or attachment, or on application to the court by him not being entertained until he has purged his contempt. In the book, The Law of Contempt, learned authors Nigel Law and Bredan Safri stated as follows, and I quote, coercive orders made by the court should be obeyed, and undertakings formally given to the court should be honored unless and until they are set aside. Furthermore, it is generally no answer to an action for contempt that the orders disobeyed or the undertaking broken should not have been made or accepted in the first place. The proper course, if it is sought to challenge the orders or undertaking, is to apply to have it set aside. End of quote. In EcoNet Wireless Kenya Limited and Minister for Information and Communication of Kenya, Justice Ibrahim Aziz was stated as follows. It is essential for the maintenance of the rule of law and order that authority and dignity of our courts are upheld at all times. The court will not condone deliberate disobedience of its orders and will not shy away from its responsibility to deal firmly with proved contemners. It is plain and unqualified obligation of every person against or in respect of whom an order is made by court of competent jurisdiction to obey it unless and until that order is discharged. The uncompromising nature of this obligation is shown by the fact that it extends even to cases where parties affected by an order believes it to be irregular or void. End of quote. The Court of Appeal in the case of AB and another versus RB is reported in the 2016 volume of Electronic Law Reports, cited with approval the Constitutional Court of South Africa in the decision of Bushell versus Bushell, case number 364 of 2015, where it was held, and I quote, compliance with court orders is an issue of concern for society that seeks to base itself on the rule of law. The Constitution states that the rule of law and supremacy of the Constitution are fundamental values of our society. It vests the judicial authority of the state in the court and requires other organs of state to assist and protect the court. It gives everyone the right to have legal disputes resolved in the court or other independent and impartial tribunals. Failure to enforce court orders effectively have the potential to undermine confidence in recourse to law as instrument to resolve civil disputes and may impact negatively on the rule of law. End of quote. It is clear from the above narrative that the contempt of court is necessary. Contempt of court proceedings are necessary for the rule of law and administration of justice to be effective and efficacious in securing compliance with the orders of the court. What are the consequences when the court makes a finding that a party has been in contempt of the orders of the court? In the present case, the court found the second and third respondents in contempt of the orders of the court on 7 February 2018. To understand why the second and third respondents, being the senior-most officers in the police service, acted in blatant breach of the orders issued by the court, by this court, to produce the applicant before it, the court required the second and third respondents to swear affidavits to give an explanation how custody of the applicant, firstly, was removed from the court, and secondly, how the custody of the applicant was handed over to the Director of Immigrations. The Director of Immigration was also required to explain in an affidavit how he took custody of the applicant when he was under the custody of the court. In compliance with the order of this court, the said affidavits were duly filed. The second and third respondents were further required to personally appear before the court to show cause why they acted in contempt of the orders of this court and why they should not be punished for being so in contempt. The court requested the second and third respondents to fulfill the legal. The court requested the presence of the second and third respondents to fulfill the legal obligation placed upon it to require any person who is supposed to face penal sanctions to extenuate to the court before the court gives its verdict. It is the choice of the second and third respondents to appear before the court and make such presentation before the court can make its final orders. If the second and third respondents chose not to appear before court and give the extenuating circumstances, the court would have fulfilled its legal obligation of giving the second and third respondents a hearing before its final verdict. As the top police officers, the second and third respondents are required to be at the forefront in respecting summons issued to them to appear before court. The entire criminal justice system would collapse if bonded witnesses fail to appear before court to give evidence just because they are of the view that they can choose to or not to present themselves before court. The second and third respondents' work as law enforcers would be much more difficult if bonded witnesses did not appear before court. Since the court has fulfilled its legal obligation to hear the third respondents before its final orders, it will proceed to set out the options available to it after making the finding that there was contempt of court. Section 28 of the Contempt of Court Act sets out the punishment that should be meted out in the event that a person is convicted for contempt of orders of the court. It provides thus, and I quote, that is subsection 1, save as otherwise expressly provided in this act or in any other written law, a person who is convicted of contempt of court is liable to a fine not exceeding 200,000 shillings or to imprisonment for a term not exceeding 6 months or both. Subsection 2. Without prejudice to subsection 1, the court may order that the accused person be detained in police custody until the rising of the court. 3. Subsection 3. A court may at any time revoke an order of committal made under subsection 2, and if the offender is in custody, order his discharge. Subsection 4. Subject to subsection 1, the accused may be discharged or the punishment awarded may be remitted on apology being made to the satisfaction of the court. Subsection 5. Notwithstanding anything contained for the time being in force, no court shall impose a sentence in excess of that specified in subsection 1 for any contempt, either in respect of that court or of court subordinate to it. Subsection 6. Notwithstanding anything contained in this section, where a person is found guilty of civil contempt, the court may, if it considers the fine will not meet the ends of justice and that imprisonment is necessary, direct that the person be detained in civil jail for such period not exceeding 6 months as the court may deem fit. End of quote. Under the above act, this court has the option of either imposing a fine or give a custodial sentence or both. This court has other options to secure the respect of court orders and meet the ends of justice. The court may direct the contemptors to take positive action to purge the contempt. In the circumstances of this court will exercise the third option as imposing a fine or committing the second and third respondents to prison may not serve the ends of justice. May not serve the ends of justice in the particular circumstances of this case. In that regard, this court will not convict the second and third respondent, but will give them an opportunity to assist the court in purging the contempt of the orders of the court that they have been found by this court to have committed. Earlier in this ruling, this court gave a narration of the events that transpired since the arrest of the applicant to his deportation on 6th February 2018. It was evident that the second and third respondents illegally held the applicant in custody on 2nd February 2018 to 6th February 2018, when, contrary to the specific orders of this court, they handed custody of the applicant to the Director of Immigration. In his affidavit, Major General Gordon Kialangwa deponed that he did not act in breach of the orders of this court because he was not party to these proceedings, and further, that he was not aware of the orders that had been issued by this court. This court evaluation of the facts before this court clearly leads it to make the following findings. 1. The National Police Service and the Directorate of Immigration are both under the Ministry of Interior and Coordination of National Government. 2. The event that triggered the applicant's deportation was a letter written by the Canadian High Commission to the Ministry of Foreign Affairs raising concerns of the applicant's detention and the fact that he had not been treated in accordance with the law. 3. The letter was received by the Ministry of Foreign Affairs on 6th February 2018. It is instructive that this letter was produced before this court by the Director of Immigration on 7th February 2018 in a bid to justify the action that he had taken to deport the applicant. 4. The Director of Immigration in his affidavit saw that he gave advice to the Cabinet Secretary in charge of immigration, that is the Ministry of Interior and Coordination of National Government, to have the applicant declared a prohibited immigrant and further to withdraw his citizenship and consequently his Kenyan passport. 5. It was clear to this court that the Director of Immigration would not have had the custody of the applicant if the second and third respondents had not facilitated it. 6. The Director of Immigration, being aware of the contents of the letter written by the Canadian High Commission, was aware that at the time, that is 6 February 2018, the applicant was under the custody of the second and third respondents who had been directed to produce the applicant before the court. 7. The Director of Immigration cannot therefore claim that he was not aware of the orders of this court or that he was aware that the applicant was required to be produced before this court to be dealt with in accordance with the law. 8. It was clear that from the affidavit sworn by the second and third respondents and the Director of Immigration that the three officers acted in concert and in a coordinated manner to defeat the ends of justice. 9. The court has reached this finding on the following basis. A. The second and third respondents were already in contempt of the orders of this court when they retained custody of the applicant on 6 February 2018. B. When the officers under the second and third respondents' command took the applicant to Kajiado Chief Magistrate's Court, Honorable Edwin Mulochi, Resident Magistrate, directed the officers to produce the applicant before this court by 3 p.m. on the said 6th February 2018 so that he could be dealt with in accordance with the law. C. That order was specific. The police officer under the command of the second and third respondents were at the time holding the applicant as a ward of the court. The applicant was no longer under the custody of the police since the applicant had already been produced before court. D. The said police officers were at the time bound by the order issued by Honorable Edwin Mulochi to produce the applicant before this court. E. When the court held its session at 3 p.m. on 6 February 2018, it was informed that the police officers in question were on the way bringing the applicant to be presented before the court as ordered by Honorable Edwin Mulochi. F. The second and third respondents are, as already stated earlier, acted in contempt of the orders of this court by failing to produce the applicant before this court for the purpose of the applicant being dealt with in accordance with the law. G. That the second and third respondents were acting in coordination with the Director of Immigration. H. The decision by the second and third respondents to take the applicant to Inland Container Depot Police Station at Embakasi instead of producing him before the court was with a view to facilitating the Director of Immigration to have his custody. I. It was not fortuitous or by chance that officers under the Director of Immigration found in quotes the applicant at the precinct of Inland Container Depot Police Station. This was planned. It was also in contempt of the orders of this court. It appeared that the Director of Immigration was and is laboring under the illusion that since he was not party to these proceedings, and further that since he purported not to have, in quotes, been aware of the orders of this court, then he would act with impunity and take custody of the applicant. As stated earlier in this ruling, both the Directorate of Immigration and the National Police Service are under the Cabinet Secretary, Ministry of Interior and Coordination of National Government. The Director of Immigration got access to a copy of the letter written by the Canadian High Commission to the Ministry of Foreign Affairs. He got access to the letter the same day that it was received. He acted upon it as part of a member of the government. As part of a member of the government. He got access to it as part of a member of the government when he knew the applicant was under the custody of the court. This court has power to hold accountable third parties who, in furtherance of contempt of the orders of the court, assist the primary contemnants to commit contempt. In the case of Eliud Muturi Mwangi versus LSL Lufthansa Services, the court said this: the law is that any person who has committed an act of contempt is liable for indictment. Therefore, even third parties who are not parties in a suit may be committed for contempt of court, and classic examples are contempt on the face of the court, contempt by officers of a company or corporation, contempt by persons who are claiming under the title of a party in a suit or as assigns or successors in title. End of quote. The Court of Appeal in the case of Shimas Plaza Limited versus National Bank of Kenya Limited, it's reported in the 2015 volume of Electronic Kenya Law Report, reiterated the importance of respect for orders of the court and the obligation by both parties to the suit and third parties who may be beneficiaries of acts in contempt of orders of the court. In that case, the court held that the orders earlier issued stopping the transfer of a property to a third party still held even after the property had been transferred to third parties who may not have been aware of the court order. In the present case, it is clear that the second and third respondents acted together with the Director of Immigration to defeat the orders of this court that required the second and third respondents to produce the applicant before this court so that he could be dealt with in accordance with the law. It is right that any action done in contempt of the orders of the court is illegal and has no capacity of being given recognition in the eyes of the law. It is evident that the action taken by the Director of Immigration in furtherance of the contempt of the orders of this court is illegal, null, and void, and cannot have any legal effect. As of 3 p.m. on 6 February 2018, the applicant was required to be presented before this court. In fact, at that time, although the applicant was under the custody of the police, he was aware of this court pursuant to the order issued by Honorable Edwin Mulochi at Kajiado Chief Magistrate's Court. This court is of the view that to remedy the contempt of the orders of this court, it shall give orders that shall give the second and third respondents and the Director of Immigration the opportunity to purge the contempt and in the process assert the authority of the court. The only way that the second and third respondents and director can purge the contempt of the orders of the court is by restoring the status quo as it existed at 3 p.m. on 6 February 2018. Mrs. Alice Chege is my daughter's favorite teacher at Alliance Girls High School. When the performance of a student who normally performs well drops, she usually makes the following statement: we must restore the factory settings. This is in allusion to a mobile phone whose software has been corrupted, and for it to function again, its setting must be restored to the factory settings. In Mrs. Alice Chege's situation, it means that the student must strive to improve performance to be as it was before. In the circumstances of this case, the purge of the content of the orders of the court, the status quo ante must be restored. These are the orders this court will make to give opportunity to the second and third respondents to purge the contempt of the orders of this court. 1. The declaration dated 6 February 2018 issued by Fred Matiang'i, Cabinet Secretary, Minister of Interior and Coordination of National Government in respect of the applicant on advice of the Director of Immigration under Section 33(1) of the Kenya Citizenship and Immigration Order Act 2011 is hereby declared null and void and of no legal effect because it was issued in contempt of the orders of this court. The declaration dated, that is number 2, the declaration dated 6 February 2018 issued by Fred Matiang'i, Cabinet Secretary, Minister for Interior and Coordination of National Government in respect of the applicant on the advice of the Director of Immigration under Section 43 of the Kenya Citizenship and Immigration Act 2011 is hereby declared null and void and of no legal effect because it was issued in contempt of the orders of this court. 3. The valid Kenya passport of the applicant shall be surrendered to the Deputy Registrar of this court by the Director of Immigration within 7 days of this ruling. That passport shall be dealt with by the court with jurisdiction in accordance with the law. 4. The second and third respondents shall personally give a written undertaking to this court that they shall comply and give effect to the orders of this court. The undertaking shall be presented to this court within 7 days of this ruling. 5. For avoidance of doubt, upon compliance with the orders of this court, the second and third respondents and the Director of Immigration are at liberty to defend the validity of the action before a court of competent jurisdiction. 6. Leave is granted to the second and third respondents and any aggrieved party to appeal against the decision of this court. Those are my orders.
My Lord, we are most obliged to ensure that all our children go to Alliance.
My Lord, before you rise,
I'm through, Mr.
oh, very well.
Hey,